First up is AGC versus Gregory Allen Slate, attorney grievance number 5. Wait just a moment. All right, Mr. Slate, please.
Good morning, Your Honors. If it pleases the Court, my name is Gregory Allen Slate, and I'm the respondent in the matter before you today, Attorney Grievance Commission versus Gregory Allen Slate. I'm going to respectfully request that this Court look at 3 issues today. The first issue is whether or not the trial court's factual findings concerning my belief with respect to the disclosures that I made on my bar application can be reconciled with the legal conclusions that I violated the rules such that the elements of knowledge and intent can survive. The second is whether or not the disclosures on my bar application and during the process were actually sufficient. And the third, those objections to the sufficiency of the factual findings by the trial court. But before I go into the substance of each of those issues, I would like to briefly address the opinions at issue, which AGC alleges were not disclosed. And while I don't believe that the substance of that order is what we're here today to discuss, AGC has, at various times during the process, repeated some of the more salacious allegations in that order, such that it would appear that they want you to know what's in there. And obviously, you're familiar with it through this case. But what I would like you to consider about those opinions is that while I don't agree with all of the allegations in the court's factual findings in that case, the one thing that I know for certain is that I'm a very different person today than I was when those allegations were made. And while it has cost me dearly, both financially, in terms of my reputation, and my ability to work and do the things that I want to do, which is make a positive impact, it has had one positive effect on me, and that's it changed me for the better. When those allegations were raised, I resolved in that moment that I would never make myself vulnerable to such allegations. And through the course of my life, I had done things that made me susceptible to the allegations that were made against me in that case, and that ultimately led to it being dismissed. So I would just like for you to consider that as we proceed. Turning back to the issues that I'm asking the court to address today, with respect to the trial court findings, with regard to my belief about the sufficiency of my disclosures, the trial court made 2 critical factual findings. The first appears on page 14, and that factual finding is that respondent believed the Howell opinions were disclosed, at least constructively, to the State Board of Law Examiners and the Character Committee. The second appears on page 20, and that is that respondent, to this day, does not believe he was required to disclose, discuss, or supplement the Howell opinions and the findings therein to his bar application. And my position today is that if those factual findings, which AGC has not objected to, and I certainly haven't, stand, I believe that on their face they demonstrate that I could not have had and did not have any intent not to disclose this information because I thought, based on my discussions with the State Board of Law Examiners, their explicit instructions to me, and the fact that I provided so much detailed information about the case that those opinions were issued in, and subsequently the appeal that placed every one of those issues in the opinion at issue before the court. And I did honestly believe that the Character Committee and the State Board of Law Examiners would look at those cases. I understand now that that didn't happen. I wish that I had acted differently, but I believe that my actions were very reasonable and that I demonstrably did what any reasonable, prudent attorney would do in the situation, which is to go seek out information from people that should know, such as the State Board of Law Examiners, the people at my law school. And based on those exchanges, I did what I believed I was supposed to do. Should I have done it differently? Absolutely. There's no question about that. But the record reflects that I didn't do what I wanted to do, which was to produce volumes of information along with my bar application, because that's what I thought would have been the most prudent thing to do. But I didn't, because the State Board of Law Examiners told me half of the bar application process is about demonstrating that you can follow directions. So follow the directions. If we need more information from you, we will ask you for it. You'll have an opportunity and you'll have an obligation to discuss everything that's in that bar application. And I ultimately did. And the trial court also found, as a matter of fact, that I further disclosed to my character interviewer that the ABC case was dismissed for discovery violations. And that brings me to the second point, which is that I believe, based on this court's past precedent and based on my understanding of how the character review process is supposed to work, that in supplying all of the information that the bar application asked for concerning these matters, that is on its face sufficient. And subsequently, the State Board of Law Examiners has changed the bar application because of this case to go a step further, and I believe that that implicitly reflects that the State Board of Law Examiners could also see how a reasonable person could interpret the bar application the way that I did. So they changed it to make sure that it specifically requested and requires bar applicants to produce certified copies of such orders. And the record further reflects that if that question or that request had been on my bar application, I would have done exactly as I was instructed. And I would submit to the court that the most compelling evidence of that is that before any of these allegations were raised, before any complaints were received, in my applications to other jurisdictions that asked me to produce copies of those documents, I did without hesitation. And I would have done the same in Maryland.
So you're barred in more than this state at this point?
My bar applications have not, some of the jurisdictions where I have pending bar applications have explicitly told me that they're not going to make a determination with regard to my admission until this matter is resolved.
Are you barred in any other states?
I apologize. No, I'm not. I am practicing pro hoc vici in New Jersey and in the District of Columbia presently. But I haven't looked through any of those applications. They're all pending, and I believe that the resolution of this will ultimately facilitate the resolution of those.
Did that cause these findings in the Howell opinion cause a problem with the New Jersey application. You say you submitted it in 2015. This proceeding wasn't started till 2017 here.
Correct.
What happened in New Jersey between 2015 and 2017?
I was brought before a panel of a formal panel to question me concerning the opinions and all of the other disclosures in my bar application. And Jersey has indicated to me that they believe that they'll have an answer for me by the end of the month.
But the opinions caused the problem with your New Jersey application.
Oh, certainly.
So didn't
Yeah, I
that
believe.
clue you into it being a problem here?
Well, when I was going through the process in Maryland, those opinions were still on appeal. It was still an active going matter. And my understanding was that factored into the character committee's treatment of that order, because it could have easily been overturned. So I didn't. No, to answer your question, the issues and the way that New Jersey addressed those opinions did not make me change anything that I believed about the process in Maryland.
When you filed the full text of the opinions with these other states along with your application, was that before or after the Attorney Grievance Commission had began its investigation here in Maryland?
Before. And I believe that's been evidence in front of the trial court.
Your application to Maryland was filed in 2014,
Correct.
and in 2017, the federal appellate court affirmed the D.C. District Court. Is that correct?
I'm not certain on the dates. I believe that it was probably early 2015 that the appellate court
Affirmed.
affirmed. I believe.
Did you feel you had an obligation or duty to report that affirmance to supplement your application to Maryland?
To be quite honest with you, I didn't even understand that once I had been admitted that there was any even mechanism or that I had the ability to provide anything further to my bar application.
Well, you signed an affirmation in 2017 that the information in your application was correct?
In my Maryland application,
Yes.
I believe that affirmation would have been in 2014.
Did you sign an affirmation that the Maryland application was correct?
Yes.
And when did you sign that?
I believe it would have been in November or December 1 of 2014, the month that I was admitted.
Maybe this is a mistake by the hearing judge. It's on page 7. On November 2nd, 2017, the respondent signed an affirmation by general bar applicant by which he reaffirmed under oath that all the matters contained in his bar application were true and correct.
I believe that's a typographical error.
We'll ask
Okay.
bar counsel about it. We'll ask
I
bar
recall
counsel.
seeing that and
If it was
recognizing that.
2017, by that time, you were clued in to the fact that the Howell opinions were a problem in New Jersey.
Yeah, I think that that's fair.
All right, we'll ask bar counsel about the date.
And the volume of the issues that I've raised with respect to the factual findings and some of the factual findings that the trial court didn't ultimately reach, I won't go into all of those because I don't believe that we have the time. But I think most importantly, the trial court's failure to find that the ABC opinions were appealed, which is plainly printed, that the appeal of those decisions were disclosed, and it's plainly printed on the bar application, while finding that the ABC, the underlying case was disclosed, but then not going the next step in finding that the appeal of the opinions was also disclosed. I think that the disclosure of the appeal of the opinions is more probative and provides more information about those opinions than even the disclosure of the underlying case itself. I thank you for your time, and I'm happy to answer any further questions.
All right. Thank you, Mr. Slate.
Thank you.
Mr. Hine.
Good morning. May it please the Court. Judge Beryl Howell of the U.S. District Court for the District of Columbia issued 2 opinions in the ABC News case that is the core subject of the failure to disclose by the respondent on his bar application. The first of those was issued April 23, 2013. And in that opinion, as found by the hearing judge in this disciplinary matter, at pages 2 and 3 of the opinion, Judge Howell made findings indicating that the respondent had submitted a letter dated August 21, 2006 that was not authentic and had been presented to the court in bad faith, that same August 21, 2006 letter contained a glaring historical inconsistency that led Judge Howell to conclude that the letter was fabricated after the fact. Judge Howell determined that the respondent's deposition testimony in the ABC News case was likely perjurious or at the very least intentionally misleading. Judge Howell further found that the respondent engaged in a course of conduct which demonstrated to her that he does not take seriously his obligation to litigate in good faith. And she further found that Mr. Slate lacked respect for the federal judicial process. All of these findings were contained in that April 23, 2013 opinion, which was issued more than a year before Mr. Slate applied for admission to the Maryland bar.
So in his application, Mr. Hine, was there a reference to that opinion? Was there a citation to it so that the character interviewer could have found it, or what? I get a sense from Mr. Slate that that's what he's suggesting.
Your Honor, what Mr. Slate is attempting to suggest to this court is that by simply disclosing that he had been a party to this litigation that has been referred to as the ABC News case, that was sufficient disclosure, and that then placed an obligation upon the character committee to go into the records of each of the cases that he listed, which in Mr. Slate's case was extensive. He listed 43 separate civil matters to which he had been a party, plus over 20 criminal and traffic matters, I believe, that were disclosed in response to a different question. That, Your Honor, was not sufficient disclosure and made no specific reference to any of these findings that I have just recited from Judge Howell's first opinion. And continuing on with her subsequent opinion and ruling on the respondent's motions for reconsideration on December...
Just one moment, Mr. Hine. I didn't understand the answer to the Chief Judge's question. Was there a citation to that opinion?
When you say a citation, there was a case number and the name of the court, the District of Columbia, the U.S. District Court for the District of Columbia, were disclosed. That was it. There was no other citation provided, just the fact that he had been a party to this case and that he provided the case number and the court in which it was filed.
Okay, and a date?
And, I'm sorry?
The date?
The date?
Date of the case? The date the...
I don't believe he referred to the date of the opinion in any way. And what's important also to recognize, question 11 of the character questionnaire asked for disclosure of all civil cases to which the applicant has been a party, and also has a subpart to that question. Please indicate if any judgment has been entered against you. The respondent, Mr. Slate, answered no to that question, which then meant, as subsection C, I believe, of question 11 required, that he did not provide a copy or submit to the State Board of Law Examiners a copy of the opinion. So, having failed to disclose that there was a judgment entered into the case, we get ahead in the bar application to question 18.
Mr. Hines, before you go to question 18, were the opinions published such that if you looked up the citation of the case, you could pull up these opinions?
Your Honor, I don't actually know the answer to that question, whether it was published in the reports for that. But I can tell you that Mr. Slate did not provide any citation to the opinion if it was in fact published. And moreover, again, going back to question 18, which asks, have there been any circumstances or unfavorable incidents in your life which may have a bearing upon your character or fitness to practice law? Not called for by the questionnaire or disclosed in your answers. Mr. Slate answered no to that question. And that question also includes a subpart that says, if so, give details including any assertions or implications of dishonesty, misconduct, misrepresentation. That is precisely what Judge Howell found in both of her opinions.
And the date on page 17, I'm sorry to interrupt, the November 2nd, 2017 date that the hearing judge found the affirmation was signed by, is that an error?
That is an error, yes, Your Honor. That should be November 2nd, 2014. That was just a typographical error.
Okay.
I also wanted to point out, in connection with the findings that Judge Hong made in her recitation of Judge Howell's opinion, she has some incorrect page citations for the subparagraphs 1 through 5 on pages 2 and 3 that I believe all of those findings by Judge Howell are contained at pages 31, 32, and through 35 and 36 of Judge Howell's opinion, which is Petitioner's Exhibit 2 in the exhibit binder that was received by the Circuit Court.
And just another question. In his remarks, the respondent pointed out two locations in the hearing judge's opinion, page 14 and page 20, where he believes the hearing judge found that he believed or intended to disclose the Howell opinions. So when you look at page 14 and page 20, the question is, reading this opinion in context, is the hearing judge simply summarizing the respondent's allegations that he testified to at the hearing, or is she making factual findings that he believed he disclosed the Howell opinions?
I would agree that it is the former, Your Honor, that if you read Judge Hong's findings of fact in their entirety, it's apparent that through page 14, when she goes to the subsection titled Conclusions of Law, that she was providing a certain summary of evidence that was received, which included the respondent's testimony, and she introduces that paragraph by stating that the respondent then engaged in a lengthy monologue, which divulged into his pre-law endeavors, and that final sentence is an expression of what the respondent testified to, that he believed the Howell opinions were disclosed, at least constructively, not necessarily reflecting Judge Hong's finding of fact on that subject. And if you read, and she incorporates additional findings of fact in the conclusions of law section, and the key findings pertaining to whether the respondent made the necessary disclosure begins in the paragraph at the bottom of page 15, continuing into page 16, where Judge Hong wrote that the facts and circumstances giving rise to this disciplinary hearing, i.e. the Howell opinions, were never disclosed in their entirety at any stage of the bar application process. And she goes on to describe that the respondent, in his meetings with the Character Committee representatives, used benign terms to describe Judge Howell's findings and distracted the Board of Law Examiners and the Character Committee with extraneous information concerning this individual named Mr. Kamau, to whom Mr. Slate seemingly attempts to attribute much of the problems that arose in connection with the ABC News case. But ultimately, Judge Hong makes the finding that at the end of that paragraph that the respondent knowingly omitted the Howell opinions and the findings therein throughout the entirety of the bar application process. And in this matter, the testimony was provided by the members of the Character Committee who met with Mr. Slate, Joseph Campo Felice, who was the assigned Character Committee interviewer, and then William Brennan and Roger Thomas, who were the co-chairs of the Character Committee for the Fourth Appellate Circuit. All of these individuals testified to the fact that Mr. Slate's application was a bit of a borderline candidacy in the first place because of his history of litigiousness, and they testified consistently that Mr. Slate did not disclose to them any of the specific findings made by Judge Howell, and that had they known about those findings, they certainly would have recommended that a hearing be conducted concerning Mr. Slate's application.
This is per their testimony before the hearing judge in the present matter?
Yes,
Before
Your Honor.
Judge Hall?
Yes, Your Honor. And that demonstrates and is incorporated in the findings of the hearing judge that Mr. Slate's failure to disclose this material information from Judge Howell's opinions clearly inhibited the ability of the Character Committee interviewers to make a fair assessment of his character and fitness.
Now, what did they ask him about that opinion? Did they mention it at all?
There was discussion of the case generally, as the testimony of those individuals reflects, and it has to be understood that they were trying to go through a list of 43, I believe, separate civil cases that Mr. Slate had listed.
This was the most recent, right? Was it not?
I'm not sure that it was the most recent. It was certainly one of the more recent ones. But in discussing that, all of them described to a certain extent, I think Mr. Brennan perhaps more than the others, that Mr. Slate described the issues that had arisen in the ABC News case as some type of discovery dispute that had come up, but did not go into the very specific findings that he had been found to fabricate a letter, that he engaged in intentionally misleading, if not perjurious, testimony during his deposition, that the judge had made specific findings that he engaged in bad faith behavior in the litigation process. And all three of them testified that, yes, this was certainly material information that should have been disclosed to us as part of the character review process. And had we known about this, we would not have made the recommendation that ultimately was made that Mr. Slate go forward for admission, at least not without a hearing being conducted.
We had a case a few years ago involving an attorney who, I've forgotten the details of it, but she had engaged in bad faith litigation. I believe she had withheld some discovery intentionally. Is this ringing a bell with you?
Withheld, I'm sorry, what did she?
Withheld some discovery.
Intentionally.
And there may have been a misrepresentation to the court about it. She was an attorney who did these things in, I believe, New York, because her law firm had been in New York. But she had a house in Maryland, and she had a Maryland bar membership.
I'm sorry, Your Honor, that case is not ringing a bell with me at this particular moment.
Right.
But I will segue from that into this court's discussion in its lineage of cases, both in bar admission matters and in disciplinary cases that involve failing to disclose material information during the bar admission process. And as the court is well aware, consistently the court has stated that absolute candor in the bar admission process is a requisite of admission to the bar, and that lack of candor, which frustrates the intent as well as the purpose of the character interview, is a reason not to admit individuals to the bar if it's determined in the course of the bar admission process. In the Van Dusen case that was issued in 2015, Judge McDonald, writing for the court, notes that a lawyer at minimum must be trustworthy, and that one who wants to be a lawyer must disclose to the State Board of Law Examiners and this court information that bears on that trait. Failure to satisfy those requirements may prevent admission to the bar, or when discovered, result in disbarment. That is precisely what we have here today, Your Honor.
Mr. Hine, I recall reading it in the papers, and I believe, if I understood Mr. Slate correctly this morning, he alluded to it, albeit briefly, that he consulted with State Board of Law examiners, and I believe also with someone at the law school.
Yes, Your
That
Honor.
he was concerned about what he needed to do in order to complete his application. Did either or both, I believe they may have, testify at the hearing before Judge Dean Diamond and Mr. Shipley?
Only Mr. Shipley.
Mr. Shipley,
Mr.
okay.
Shipley did testify in this proceeding and described whatever communication that took place between himself and Mr. Slate as very general in nature and not involving any specific advice beyond reading and following the instructions contained in the bar application. Mr. Shipley certainly was not made aware of the contents of the Howell opinions, nor did he provide any advice to Mr. Slate concerning whether or not the contents of those opinions should be disclosed.
So in his testimony before Judge Hong, did Mr. Slate testify about either of those two encounters?
Yes, Mr. Slate testified as to both of those encounters, but his testimony is rather general as to Mr. Shipley. The court had already heard from Mr. Shipley prior to Mr. Slate's testimony, and so Mr. Slate was only permitted to give his side of what those encounters encompassed, which, again, even in Mr. Slate's own testimony, I don't believe he indicated that he had disclosed the specific contents of Judge Howell's opinions to Mr. Shipley. And with regard to Dean Diamond from the University of Baltimore Law School, the court did admit into evidence an email thread that is essentially just to do what the instructions tell you to do, but there's no indication in that email thread that Dean Diamond was aware of the contents of the Howell opinions or that they had been discussed in any detail, nor is there any indication, and I think it would be unfair certainly to Dean Diamond, who was not called as a witness by the respondent or otherwise testify in this matter, to suggest that she knew of the findings and gave her blessing, so to speak, not to disclose that.
Mr. Hine, can you discuss somewhat the concept of whether a person can be sanctioned under the MLRPCs for conduct that occurred before they were admitted to the bar?
Before they were admitted to the bar, an attorney, after being admitted to the bar, may be sanctioned for misconduct that violates Rule 8.1, including subsections A and B, which specifically includes the language that an applicant for admission to the bar shall not knowingly make a false statement of material fact and shall not fail to correct a misapprehension known to have arisen. And we have made the argument in our exceptions that Rule 8.1b is implicated as well as 8.1a based upon the information that Mr. Slate failed to provide disclosure to the character committee members with whom he met about the contents of the Howell opinions, and therefore in their discussions as described in their testimony, they were proceeding in their discussion of the ABC News case simply with the understanding that it was contentious litigation involving discovery disputes, but not with any specific information that Mr. Slate had been found to engage in conduct involving dishonesty and misrepresentation, about which they certainly would have made further inquiry had they known about that.
What about 8.4c?
And 8.4c, it should be noted initially that one of the grounds for 8.4c is that the respondent, in his response to Bar Counsel's letter, when this matter was first brought to our attention in the George Weiss complaint, made the statement that he disclosed everything necessary and more during the character review process. And the hearing judge, Judge Hong, specifically found that that was a false statement and that it violated Rule 8.1a, and that also violated Rule 8.4c. This court in the Van Dusen and the Hunt cases, I believe, has also held that there is this ongoing obligation to disclose material information that an attorney has after admission to the bar, and that looking at the Van Dusen case, if an attorney does nothing to correct a material omission with either SBLE, the commission, or this court, that this deliberate failure to disclose supports a violation of Rule 8.4c. So under all the circumstances in this case, we believe disbarment is warranted.
All right, thank you, Mr. Hines. Mr. Slate?
Thank you, Your Honor. I would like to address some of the questions from the court. With respect to references to the opinions on the bar application, the record in the trial court reflects, and so does the bar application plainly, that the date of the opinion was printed on the bar application in response to the question on the bar application date of dismissal with respect to that case. Further, I'd like to address the court's questions concerning whether or not this opinion was published. I think to say that this opinion was published is an understatement. It was so publicly available that lay people who I encountered in any context in litigation would take the order and publish it into that case in an effort to persuade the court that I was a bad guy, put this information in front of the court to gain an advantage.
May I interrupt you for a moment? In listening to what you've just said, Mr. Slate, tell me if I misunderstand. It sounds to me as if what you're suggesting is that there was an obligation on the part of the character interviewer or the character committee or someone, Sable, to actually do the legwork. You say it was available to the public. Well, that may very well be so, but the burden seems to have, you seem to be making the argument that the burden is upon individuals within the character review process rather than the applicant to do some digging, do some investigation. Am I hearing you correctly?
I apologize for not being clear. What I was trying to convey to the court with respect to the availability of the order was just with respect to what I believed. It was so available that I just didn't, it did not occur to me that it was possible that the character committee members weren't aware of it.
Is the letter, is the August 21st, 2006 letter that is in controversy, is that in the record of this case?
In the record of the case before us today?
Yes.
I don't believe that it is.
So, and has it ever been described other than as a letter that was not authentic and had been presented to the court in bad faith?
And has it ever been described in this case?
In this proceeding, yes.
I don't believe that it has,
Okay.
other than the extent to which it's been characterized in the opinions that are in the record. Excuse me.
Is it, and one more question, has Westlaw published the Howell opinion? Is that how people are finding it, or?
I believe the answer to that question is yes, Westlaw has published it. It was further published by various legal news
websites.
publications. So if you were to Google Greg Slate, it's pretty much the first thing that you're going to see.
We don't normally do that.
I understand. I would like to just address the court's findings concerning my answers and failure to provide these opinions in response to the requests on the bar application for judgments. And I believe those questions, when read in context, appear to be referring to money judgment. The next question after, are there any judgment, has a judgment been entered against you, is a follow-up question, has it been satisfied? My understanding and the way that I read the bar application was that this was not, these opinions were not of that character, that's what the bar application was seeking information concerning. I thought that the bar application wanted to know if you had an outstanding money judgment, and if so, to provide a copy.
I want to be sure I understand what, for me at least, is somewhat central to all of this. You were aware, obviously, of Judge Howell's view of your actions and inactions during discovery and her findings. Were you counting on the D.C. Court of Appeals to have found them to be clearly erroneous? And at that stage, you thought it was, I mean, you tell me, is that what motivated you not to include information along that line in your application, is my question.
What motivated me not to include anything additional with the application was the instructions that I got from the State Board of Law Examiners before and while I was completing the
Which were essentially answer the questions, right?
Answer the questions, follow the directions, and I believe that Mr. Shipley testified at trial when asked if he had instructed me not to provide any other documents other than those called for, those asked and requested for by the bar application. I believe that his response was that he believed that that was part and parcel to what he had told me.
Well, insofar as those findings by Judge Howell speak of some dissembling and bad faith, you felt no compulsion to answer question 18 other than you did, which was no? I think you just answered no, didn't you? There's nothing else that would...
There was the supplement
Yes.
attached to the bar application when it was initially submitted. I should have answered that question, yes, just by virtue of the fact of the girth of my litigation history and the volume of matters that I've been involved in before law school and during law school.
Well, the answer yes would have taken the character interview process down a different path altogether. You would acknowledge that now, I assume.
I believe now that it would have, yes. I'd also like to briefly address the 8.4 violation and the Attorney Grievance Commission's position that my statement in response to their letter that I had disclosed everything necessary and more was a knowing misrepresentation on my part. I do believe it is important for the court to consider that I was responding to a letter that was 14 pages, and it submitted that I hadn't disclosed a lot of things and just generally tried to provide as much detailed information about me as it could, and speculated that something must not have been disclosed. In the context of, it's also important to note that the record reflects on the complainant concedes that there was a number of information in that letter that just wasn't accurate. There were assertions made that I was affiliate, that I'd been involved in litigations in places and states that I'd never been. So in responding to a letter that had some misinformation in it and that didn't include all of the things that I'd actually disclosed on the bar application, failed to identify cases and matters that were clearly disclosed on the bar application, that was the sentiment behind the statement. I disclosed everything necessary and more, and I believed that I had, and I knew that I had disclosed more than the information that was in the complaint, and that was the motivation behind the statement. never believed or conceived that the answer to what I disclosed in my bar application would come from ultimately me. The bar application speaks for itself, so I can't conceive of any motivation that I would have had to misrepresent that to the Attorney Grievance Commission. I was merely trying to respond to a voluminous complaint and cooperate with that investigation.
Do you want to address at all the sanction potentially?
I believe that under the factual findings of the court and the finding that my belief that I had sufficiently disclosed is actually an aggravating factor, that if this court believes that I intentionally didn't disclose this information and tried to withhold it, I don't think that I could stand here in front of the court today and say that I believe that any other sanction other than what AGC has suggested is appropriate. I think this is an all or nothing scenario. I either did it and I did it on purpose, and I did it because I was trying to conceal and gain an advantage, which I know wasn't the case. Or I did everything that I thought I was supposed to do. And that's the reality. I appreciate the court's time today.
All right, thank you, Mr. Slate. Mr. Hine. Next up is number 37, Green versus State. Good morning, Mr. Ross.
Good morning, and may it please